My name is Delene Grant, Ontario Superior Court of Justice, motion record and order. Okay, it's now tab F. As you can see, there's a tab, and now I'm on F right now. Okay? F, amended statement of claim. So, amended, why should it be included? All right, please feel free to review. Amended statement of claim saw this amendment for the first time on September 10, 2020. Amended statement of claim dated July 17, 2019. I was confused and had questions I did not understood then. Why did the lawyers combine both wrongful dismissal and long-term disability cases? Both claims should be separated since my issues differ with mobility and MANULIFE insurance. Since retained NAIMARK clause showed no interest in my cases, but deliberately delayed my cases with ridiculous excuses. 1 year and 2 months later, this lawyer had not met with me to discuss my cases, but chose to combine my cases to further delay my claims. As you can see here, when Courtney stated, that got me confused because I didn't realize that it was from NICOLINI law. But anyway, NAIMARK law was also involved. Courtney Madison made a statement of claim July 2019. When I asked for a statement of claim, could I see it? Because the examination for discovery for September 29, 2020 was around the corner. And I didn't know what I was up against. So I asked, can I review the statement of claim? This is when now she sent them. But afterwards she said, on September 10th, as you see, Courtney said, hi Delene, take a look at this one. This is the amended statement of claim. The earlier ones were issued by your prior law firms, and this amended version adds them all together. You notice that this lawyer do not understand my case, or she was just being deliberate. Okay? It was stamped and from, as you can see, July 29, 2019. Okay, be free to review. This included Bell Mobility Inc. Okay. And I did make mention of it. How could this amendment be possible? By this time, after the motor vehicle accident on July 2nd, I had retained NAIMARK law on July 11, 2019. NAIMARK law requested my wrongful dismissal and long-term disability cases was retained on July 26, 2019. How could NICOLINI law, without a contract, had such power to have an amendment made to the statement of claim on July 29, 2019 and signed on July 17, 2019? As I thought, I was so confused then. I leave everything as is because I'm just like how they're trying to confuse everything. So at the point in time, I just thought it was NICOLINI law. So NICOLINI law, because if I retain NAIMARK law on July 26, 2019, how could NICOLINI law got this signed on the 17th of July 2019? I was thinking NICOLINI law, but no, this was NAIMARK law. I don't know how they did it. Wow. NICOLINI law's statement of claim always indicated Bell Canada. You know that, okay? Did they finally become wise and amend the correct company name, Bell Mobility? This time, as I said, I was still confused, but now I got it. So all of this was done by NAIMARK law, changing it to Bell Mobility, okay? Benjamin Law firm's name also appeared on the amended statement of claim. Which lawyer actually did this amendment to the statement of claim? Okay? NICOLINI law and also NAIMARK law. Please feel free to review. See here, Benjamin law name is there. NICOLINI and NICOLINI law is crossed out, So, was this correct? I'm sure Benjamin law did not combine. Okay? Feel free to review. And they included Bell Mobility. I did not retain Benjamin law for Bell Mobility. I retained Benjamin law for long-term disability. You see, the statement of claim was incorrect. we were going to meet, and then I would have explained everything to him so that he could make the adjustment, because I would not have MANULIFE insurance on my long-term disability statement of claim. All right, please feel free to review. Thank you. Deception by NAIMARK law continued, okay, because it was not certified. This combined statement of claim was not certified, and the Superior Court of Law should have recognized that. All right, please feel free to review. Thank you. No court stamp. What a mess. NICOLINI Law had made the amendment to the statement of claim. I had no contract with NICOLINI Law firm for my wrongful dismissal and long-term disability cases. After I contacted NICOLINI Law on January 8, 2019, the firm seemed to have become very active towards my cases, since statements of claim were submitted to me for the first time on January 10, 2018, 2 days later. Now, I got fired from my work on May 24, 2018. Didn't hear from Adrian NICOLINI Law firm. I went to Kevin Marshall Law in January, and that's when I had to ask for statement of claim. And since I asked for statement of claim and got it, then NICOLINI Law firm was so active. I retained Benjamin Law Firm on February 13, 2019 for my long-term disability case. I retained SAMFIRU TUMARKIN Law on March 26, 2019 for my wrongful dismissal case. Why was NICOLINI Law Firm making amendment to the statement of claim after receiving consent from the Defense Counsel on February 28, 2019? NICOLINI Law, Adrian NICOLINI informed Benjamin Law of this change via letter dated May 14, 2019. Benjamin Law was my lawyer prior to February 28, 2019. Deception. See the following communication from NICOLINI Law and compare with the letter sent to Benjamin Law Firm on May 14, 2019. Okay? Your review. I press it forward again for reference. Okay? As you can see, as after Benjamin Law contacted Industrial Alliance and in April 2019, all right, NICOLINI Law Firm contacted Benjamin Law in May 2019, a month later, okay, and talking about amendment of statement of claim to include Bell Canada. Remember that, okay? However, the interest here is the file number and the date of loss. As you can see, you know that the date of loss is May 2018. You notice that NICOLINI had it all wrong, okay? Date of loss. And then on this is my first correspondence with NICOLINI Law Firm since retained in 2017, okay? So June 2019, it stated here the file number and date of loss, September 7, 2016, and this is for Workplace Safety and Insurance Appeals Tribunal. Now listen, this date was even incorrect on my WSIB. However, it's been used across the board. You notice? How can it be used for my long-term disability? How could it? Okay, please feel free to review as I go along. Thank you. Second correspondence from NICOLINI Law Firm regarding WSIB. This was July 2nd, 2019. Okay, interest is file number and date of loss, still saying September 7, 2016, and it says Workplace Safety Insurance, okay? August, okay? 14, 2019, all of a sudden he's showing interest in WSIB. Anyway, you notice file number and date of loss, okay? And it's WSIB. So here it's saying September 7, 2016. Please observe, okay? Thank you. I brought this forward again for your review. All right, this is part of the statement of claim. Okay, part of the statement of claim to MANULIFE Insurance, which include September 7, 2016. As you can see, on or about September 2016, the plaintiff became disabled. It's supposed to be about long-term disability. Okay. All right, so here now on September 24, 2019, there's another correspondent with file number and date of loss, September 7, 2016, and this is in regards, as I made mention before, Workplace Safety and Insurance Tribunal. Please feel free to review. Thank you. Now I'm on that famous letter again, dated May 14, 2019, NICOLINI Law. All right, I brought it forward again, just for you to see the number, the number, file number, and the date. This is supposed to be long-term disability. All right. And this retainer, I did retain Adrian NICOLINI law firm, okay, for Workplace Safety and Insurance Board, and he has September 7, 2016. All right. I was injured at work, so I was off on September 7, 2016. But please feel free to review my other presentations for more details. Thank you. Now we're at G, letter dated April 3rd, 2019, and notice of change of lawyer dated April 3rd, 2019. Okay. G, as I said, letter dated April 3rd, 2019, and notice of change of lawyer dated April 3rd, 2019. Okay, now they have the Manufacturers Life Insurance and Industrial Alliance and Financial Services Inc. without Bell Mobility. Okay, this is Benjamin Law Firm. This is what Benjamin Law Firm had. Okay, just letting you know. They never combined thing. All right, April 3rd. The plaintiff formerly represented by Adrian NICOLINI from NICOLINI Law Group, and he shouldn't have. I would have clarified that because I did not sign a contract, but I didn't get a chance to. As appointed Anthony Stephen Benjamin of Anthony Stephen Benjamin of Benjamin Law as lawyer of record. Okay, and as you can see here, all right, and I retained this lawyer since February 2019. Okay, please feel free to review. Thank you. Here, everything is there. It's not, I guess, not certified as yet. Okay. I brought this forward as proof that Adrian NICOLINI Law Firm had no information regarding long-term disability, none whatsoever. You understand? When he billed Benjamin Law Firm, he charged Benjamin Law Firm. Benjamin Law Firm was duped by Adrian NICOLINI. All right, and I have the proof here. As you can see, April 10, 2017, I was still working. I was still at work. Okay, and I was at work with an injury when I retained this lawyer on 10th of April 2017. As you can see here, I retained that lawyer, NICOLINI Law Group, on September 7, 2016, and it says Workplace Safety and Insurance Board. Okay, so that's when I retained the lawyer. I was still working, right? And I paid the lawyer $1,000 plus tax, as you can recall. All right, yet Benjamin Law Firm again was charged 10th of April 2017. I was working all along. This has nothing to do with long-term disability. You understand? These are even false information here, right? Anyway, on June 5th, I did attend a meeting at NICOLINI Law Group's office, Adrian NICOLINI's office, right? But I was not retained. You see, he made mention about Bill Canada. I still didn't even know where I work. Anyway, all this information and then some are false. Please feel free to review. Okay, thank you. Please review details on the presentation, Discrimination, NICOLINI Law, creation of false statements of claim. Thank you.